Credit card abuse. What is it? If you're facing a credit card abuse charge, are you looking at a felony or a misdemeanor? Hi, I'm Jeff Hampton with the Fulgham Law Firm. I want to thank you for joining us here today. Today I want to break down Texas law as it relates to credit card abuse. What is it? What are the legal defenses that you may be able to use if you or a loved one has been charged with credit card abuse? And if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, if you're going to talk about credit card abuse in Texas, you'll have to look at Texas Penal Code, section 32.31. It states that a person commits an offense of credit or debit card abuse if the state of Texas can prove beyond a reasonable doubt that a person with intent to obtain a benefit fraudulently presents or uses a credit card or debit card with knowledge that one, the card, whether or not expired, has not been issued to him and is not issued with the effective consent of the cardholder, or two, that the card has expired or has been revoked or canceled. You can also be charged with the crime of debit or credit card abuse if an individual with intent to obtain a benefit uses a fictitious credit card or a pretended number of a description of a fictitious card, or obtained, and there's a bunch of other ones. You can actually sell a card to someone else knowing it wasn't your card. You can also steal it if you use someone else's card that you know was stolen. There's all these other examples. Now listen, I can literally give you like 7 or 8 other examples under the code that talk about what credit card abuse is. But at the end of the day, the main thing you need to know about what credit or debit card abuse is that if there is improper usage of a credit card that's not yours, or that you didn't have consent of the owner of that card, and you did it with the intent to defraud that person, you're looking at credit or debit card abuse, okay? That's what the law says. Now, is credit card abuse a felony in Texas? Yes, it is, okay? Now, the crime of the crime of credit card abuse has been labeled as a state jail felony by the Texas legislature, which means you could be facing a penalty, a jail punishment of up to 2 years in prison and up to a $10,000 fine. Now, here's the catch. If the prosecutor can prove that the person who was the victim was an elderly or disabled person, that actually elevates the charge to a third-degree felony, punishable by a minimum of 2 up to 10 years in prison and up to a $10,000 fine. Now, here's a question I get all the time for credit and debit card abuse. Does the value of the item supposedly run on the credit card, does it matter in terms of how the case is filed? And the weird thing about it is, the answer to that is no. This is one of the biggest differences between the crime of credit and debit card abuse and theft under Texas law. So although credit card abuse can be a form of theft, and that's how people think of it, the value of the items fraudulently charged on the credit card do not matter when it comes to what the charge is. So I'm going to give you an example. Let me just show you an example of what I'm talking about. John used someone else's credit card. Now, without their permission, he went to a fast food store, a fast food restaurant. He bought $5 worth of food, okay? Now, you would think $5, that's not hardly worth anything. That should be a misdemeanor, right? No. If John had walked into the restaurant and crawled behind the corner or crawled behind the counter and grabbed and stole food and ran out the front door, he would have been charged with a misdemeanor, a theft. Because the way that it works, under theft, it's graded on value. If it is $100, under $100 in value, you're looking at a Class C misdemeanor citation. But if you use a credit card fraudulently to obtain the same property, it doesn't matter whether it's 5 cents or $5 million, you're looking at the charge of credit or debit card abuse, all right? So it doesn't seem always fair, right? It says, well, that doesn't sound right. So should someone actually be punished for that just because the value of something's so small? And so there are ways that you can fight that, but I'm just letting you know that's what the law says. Now, let's talk for a few moments about the defenses to the crime of credit or debit card abuse. Now, number one we're going to talk about is lack of criminal intent to obtain a benefit. In order to be convicted of the crime of credit and debit card abuse, the prosecutor must prove beyond a reasonable doubt that you used the card of another without their consent and with the intent to obtain a benefit fraudulently. Now, here's the question. What if the credit card or debit card was used, but there is no proof that it was being used with the criminal intent to benefit anyone or benefit yourself or anyone associated with you? What if instead it was being used to benefit the person who actually owned the card? Now, I bring this up. We have seen instances where we have seen someone use a credit card without the consent of the owner, but the purchases were made clearly for the benefit of the owner of the credit card. As an example of that, we've seen family members where maybe they are not able to make their own decisions. They're in a hospital, or there's something going on, and a family member uses that person's credit card to make purchases, and then the family member gets mad about that. The person in the hospital or incapacitated gets mad and says, "I didn't give you authority." The police start investigating them, but clearly the purchases were for the benefit of the cardholder. So I'm just telling you, if they cannot prove, if the state of Texas cannot prove that there was intent to obtain a benefit by the accused, they don't have a case, okay? Now, what if there's an alibi, defense number 2? What about if there's an alibi establishing a misidentification of the suspect? What if you are the lead suspect for a credit or debit card case, but the video showing the transaction or the eyewitness statement is, let's say the video was blurry or the eyewitness statement wasn't exactly clear about who they were talking to or dealing with? It is critical that you scour through your receipts, your phone records, any witness accounts, maybe other people that might have been with you at the time of this alleged incident that took place. And if you have evidence establishing an alibi that you weren't where they said that you were, or that you were doing something else at that time, it's critical that you provide that to your attorney. Okay. Now, and by the way, I'm just as an aside, just remember, if the police call you and they want to talk to you about a credit card abuse investigation, they're not calling you because they want to really talk to you about your side of the story. They're calling you because they want to interrogate you. Okay, so I want to remind you, you have a Fifth Amendment right not to either incriminate yourself or answer the officer's questions, and you also have a Sixth Amendment right to counsel to help in that process. Because here's the key. If you start talking to the detective, especially if you're innocent, if you start talking to that detective, everything you say, not only can it be used against you, it will be, and it may be misinterpreted. How many of us have been misunderstood by someone? You try to explain something innocently, they take it the wrong way. Now the detective writes it down and it's the gospel truth. Everyone believes the detective and not you. If you hire an attorney and that attorney is involved in that process, everything your attorney says is hearsay, but yet your attorney can make sure and get the pertinent information over to that detective to show that you were innocent of these charges. So I wanted to add that in. It's very important that you are very careful and you think about it before you make a decision to have an interview with the detective if you're the subject of a criminal investigation for credit card abuse or for any other crime for that matter, okay? Now, let's talk about our next defense. What if there is a lack of proof establishing your knowledge that the card was stolen? What if you received a credit or debit card and didn't know that the debit or credit card that you had was stolen? For example, we represented a client charged with credit card abuse because he used his employer's credit card for gas to be used in a company vehicle. However, the client had no idea that the card that was given to him by his supervisor was a stolen card that he did not have the authority to be using. So in this situation, we were able to establish that the supervisor was the one that had knowledge of that, not our client. And as a result of that, there was no way that they had sufficient evidence to establish the knowledge required to convict our client of the crime, okay? Finally, what about consent? We're going to talk about the element of consent. What if there was consent to use the credit card or debit card? We find this situation arise very frequently in the employer and employee relationship. For example, what if an employee had been given permission to use a business credit card during employment, but something soured during the employment relationship for whatever reason, and now the employer is claiming that the employee did not have the authority to use that credit card? The real question here that must be explored in this situation by your criminal attorney is whether or not the person being charged, whether it's you or a loved one, reasonably believed that they had consent to use the credit card at the time of the alleged crime. If so, there's no crime, okay? There's no crime at all. Remember, your criminal defense attorney can establish reasonable doubt. If they can establish reasonable doubt regarding this issue, it can provide leverage for you in negotiating the case. Now, the last thing I want to talk about is, what if you have one of these defenses? What if they apply to you? Well, this is critical under Texas law. Because credit card abuse is a felony in Texas, every felony must be indicted by a grand jury. So one of the things we like to do here at the Fulgham Law Firm is we make sure and we take this information and these defenses as we're able to identify them from the evidence, and we want to put together an evidence packet to make a presentation to a grand jury. Please understand what a grand jury is. A grand jury is a panel of citizens that acts like a filter. They're supposed to filter out bad cases, keep good cases. But how are they going to know if it's a bad case unless they get a chance to see the other side? Okay, so you are able to have your attorney make a presentation of what we might think of as exculpatory evidence. Maybe there's evidence that establishes you are not guilty of this offense. That can be presented to a grand jury, and it is possible they may be willing to lower the charge down to a misdemeanor level offense, or they could no bill the charge. And essentially a no bill is the equivalent of the case being thrown out and that you were exonerated. But the problem is that usually happens within the first 30 to 90 days from the date of the arrest or the date of the filing of the case. So you don't want to delay as it relates to that. You want to make sure that you have an opportunity to be heard during the grand jury process. Now, I want to thank you for joining us on this video. I just gave you a little bit of a dose of what to know about when it comes to credit card abuse in Texas. But maybe you or a loved one are facing a credit card abuse case in the North Texas area. I want to offer you a free case analysis and a free consultation. This number that you've seen above me on the screen is the number that you can contact our office, and I encourage you to do that. We'll be happy to break down your situation and see what we can do to help you. By the way, I promised you if you waited around to the end of this video, I would also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link down below in the YouTube video section, and I'll be happy to send that over to you. And listen, I hope this helped you. Subscribe to our channel, like this video. We're going to continue to provide you more great content just like this. And I want to thank you for taking the time to join us here today. Take care.